taken note of is this. There is now a central agency. There is a central agency for YES, for the Youth Employment Service. And that central agency is the YES non-profit company, which is identified with their registration number in the Gazette. And it can be found at www.yes4youth, the number 4, yes4youth.co.za. This is the non-profit company, which is, for all intents and purposes, the statutory body for the Youth Employment Service. And what's absolutely critically important to note here is that triple BE recognition will only be awarded to YES measured entities. In other words, you'll only be able to be a YES company if you've registered with the YES non-profit company. Now, that doesn't mean that you work through the YES non-profit company for your YES program. It just means that you register that YES program with the non-profit company. So I know that there has been talk that, for example, and I'll just use them because they're active in your sector, Harambee is the statutory body for YES. It's not the statutory body for YES. There is no statutory body outside of this YES non-profit company. And even though the YES non-profit company might enter into alliances with organizations like Harambee, those alliances are nothing other than the registration of the schemes proposed by any company, including Harambee as a company. So I do need to emphasize and point that out. What I can tell you is that discussions are underway with the YES non-profit company to register additional contact center hubs within the, YES hubs within the contact center sector, because there's no exclusive agency in any industry or any sector. Remember what it is they're trying to do here. They're trying to get as many people into these YES positions as is possible. And remember, again, I'm just going to summarize what YES is. YES is for a person under the age of 35, between the ages of 18 and 35, who are unskilled and unemployed in terms of their work experience, coming into the world of work for 12 months, 12 contracted months, a fixed term contract of 12 months, specifically for the purpose of doing a job which exists in the business over that 12-month period. If there is training involved in that job, so be it, but it is not a training position. It is not an internship. It is not a learnership. The regulations are very specific. YES is not an internship, a learnership, or a qualification. It comes after those experiences. So if you want, it is an opportunity to extend a learnership by another year through the equivalent of a work-based experience not defined as an internship or articles or anything like that. It's quite difficult to get your head around this, and I have been contacted by a number of training providers who are remonstrating. They're up in arms about the fact that it's not training provision, that the private training providers are cut out of the loop. Well, in fact, they're not cut out of the loop. They're entitled to offer YES positions for their own benefit, or if they're QSEs or SMEs, they're entitled to offer YES incubators for their clients, their corporate clients, where the corporate clients will get the benefit of those YES incubators. And we'll talk about that a little later. So please be very aware. YES is not an internship, a learnership, or a qualification. It's what comes after those experiences. If anything, it's a fantastic opportunity to extend the specific and temporary nature of a learnership or an internship by an additional year for purposes of work placement in a real job, and importantly, at the same conditions of employment that that person in the workplace would be offered. Critically important that everybody understands that. And as we go through the regulations, I hope you'll see that. So if you go to the YES for Youth website, you will see, and this is where I think it gets very murky and gray and messy, in the sense that this statutory body, which is called yes4youth.co.za, or the YES non-profit company, is in fact an organization that has a very declared, transparent funding model which is built in that says, at the very least, from each individual who is on a YES program, we are going to collect from the employer over and above the cost of employment. We're going to collect from the employer at the very least 1,700 Rand per yes candidate, which is a once-off management, monitoring, and evaluation fee per individual. Or if it's done in-house and the company registers to manage the YES program in-house, a once-off management, monitoring, and evaluation fee per youth of 5,000 Rand. If it's done in-house assisted, which includes YES sourcing and matching of youth, which obviously is the opportunity then to marry it up with Fees Must Fall, 7,000 Rand per YES candidate, which includes once-off management, monitoring, evaluation, but also YES sourcing and matching of the youth. And if it's done to boost or build a business, to place youth inside a host of a new business, 9,000 Rand per young person. So the very least that you're going to be able to do, if you're a small business, and there is really very little distinction between the small business and the in-house deal, except for who's going to be managing it, is 1,700 Rand per yes candidate. Now remember, it's per yes candidate, not the 2.5% of those yes candidates who need to be employed at the end of the 1-year YES program. So I'll give you a practical example. A company that does 140 million Rand a year turnover, not a small business, obviously, has a YES target, has a headcount of 54 people. Their YES target is 8, and their employment target on the YES target is 2.5% or one of those 8 people. So they would pay, at the very least, they would pay 5,000 Rand per each person, or 5,000 Rand for the 8, which is 40,000 Rand, to register on the program. And then at the end of it, they would need to employ one of those 8 people. If they're one of these people, if they're one of the companies that don't want to see the person, but they're prepared to do the funding per individual, they would, in addition to the funding, the cost of employment per individual, they would pay 9,000 Rand per candidate, or 9 times 8, if that makes sense. So that's how the YES registration process with the YES non-profit company actually works or operates. Before I carry on, any questions about that? All right, let's move on. So, public entities and specialized entities may participate within the YES initiative with no... Sorry, is that someone who wants to ask a question? Oh, no, okay, it's just your microphone. Public entities and specialized entities may participate with no sub-minimum requirements, because remember, the sub-minimum requirements that we're going to be talking about in a little while don't relate to public entities or specialized entities. They only relate to private sector entities. Sub-minimums for sector-specific YES measured entities are calculated as per the sector codes for those entities. And remember that we've got roughly about 10 sector codes which vary the the generic triple BEE codes, upwards or downwards on the various elements. And in fact, some of them establish additional elements, like the MAC Charter Code establishes a 6th element. So you need to know which sector code you fall into if you're not covered by the generic codes. And you need to know whether the sub-minimums, which ordinarily say 40% of your target for ownership, 40% of your target for skills development, and 40% skills development spend, and 40% of your target on procurement, you need to know whether those sub-minimums change because you're subject to a sector code, such as, for example, the construction sector or the media advertising sector, and you're not covered by the generic code. So you need to know where you are. And your verification agent will tell you, because in fact on your certificate it'll tell you which codes you in fact have been verified against. All right. Now, if you don't meet those sub-minimum codes, exceptions can be made. And these are those exceptions which are now contained in the document. If an ownership deal terminates, in other words, you can't meet the sub-minimum on ownership, if an amendment to a sector code of good practice which results in a drop is experienced, if your triple BEE status level changes, if a decrease in the market value of the shares reduces the yes measured entity's net value. So if any of these things can be shown, then in fact you may be exempted on a case-by-case application and interaction with the yes company. You may be exempted from either one or all three of those sub-minimums being applied. Any questions about that before I carry on? Okay, remember you just need to unmute your mic to ask a question. Okay, moving on. Now, as this is the first year we're getting into the process, your target for absorption, your 2.5% of all of the candidates who've been on the YES program will not be verified for your triple BE recognition during the year of implementation, but only when absorption takes place in the following measurement period. So practically, if you are measured now against your February 2019 year end for the year 18 to 19, you won't have to be a yes company which has absorbed your 2.5% people, but in fact you will be measured after February 2020 on having successfully done that. So you'll be given the benefit of the doubt to start off with. So you will be checked by the end of February 2019. If that is the end of your financial year, you will then be checked if you're registered with YES as an entity and whether you've contracted with the requisite number of candidates in terms of your YES target, but not that you've absorbed your 2.5% people. It is only at the end of the following financial year that you will be checked on whether you've absorbed your 2.5%. That's very important. That's a good dispensation. The important thing is that the workplace experience for eligible employees needs to cover a full 12-month period. Where the person does not complete the 12-month period because of unforeseen circumstances, the YES measured entity needs to ensure that at least 8 full months have been completed to be eligible for triple BE recognition. Now remember, when we say eligible for triple BE recognition, what they mean is to be able to jump a level because you're a YES company, or 2 levels if you've doubled your target. Furthermore, so 8 is the minimum number of months out of the 12 that the person has to have been employed by you on that fixed 12-month contract of employment. If any eligible employee falls out of the YES initiative due to any circumstances, the YES measured entity will have 1 month to replace them to be eligible for that triple BE recognition. It's very, very important. I can tell you from experience with learnerships, it took a long time for companies to understand how to replace learners, what the regulations around replacing of learners were about, etc., etc. So it's very, very important you understand this, ladies and gentlemen. Okay. Absorption can only take place after the 12 months completion of the workplace experience, and the target is based on YES targets for measured entities. If absorption is identified at the time of verification, triple BE recognition will be awarded. In other words, you'll be allowed to jump a level. If, however, you've absorbed after that period, then you can be re-verified without having to wait for the end of that financial period. You can be re-verified with the additional jump by your verification agency. Any questions? I know that that's quite new to you. So any questions about that before I carry on? Okay. Very exciting. This is very, very exciting news. Charles, I hope you can still hear me because it's absolutely quiet and silent.
Hi, no, I can still hear you. I'm just listening.
Okay, good. So the 12-month workplace experience is not a learnership, it's not an internship, and it's not an apprenticeship. You need to be aware of this. I can tell you that there are many disappointed training providers out there who, it's because they're communicating with me, who misinterpreted the YES opportunity as either an internship or an apprenticeship opportunity. It is not that. It is what comes after your learnership, your internship, or your apprenticeship. It is not what comes during or before. So really, please, it is very, very important that people understand this and that training providers are not left disillusioned, because in fact those training providers are now threatening to disincentivize their corporate clients to operationalize YES and become a YES company. YES was not designed for the private or the public training provider fraternity, except as far as their own staff and their own internal YES program is concerned for their own needs. If there are any training providers in this group that want to ask a question, now's the time to ask their question. The 12-month quality workplace experience, and it's defined in the regulations what quality workplace experience means. It has to be an actual job. It has to be deployment in activities that other staff members who are on the payroll would be involved in. It has to be supervised activities in the same way that those other staff members would be receiving supervision, and preferably at least one performance appraisal process during the course of that year at least. It will be monitored by the YES. This is why you register with YES, the YES non-profit company, and I assume this is also why you pay the minimum fee per candidate, but it will be monitored. That work experience will be monitored by the YES non-profit company to ensure a consistent national standard of work experience. Sectors that are governed by employment condition legislation will be subject to those conditions, so bargaining council agreements, statutory council agreements, etc. Ultimately, the eligible employee needs to fulfill a 12-month workplace experience. Again, this is the time to ask questions if you have any gray areas about what that means. YES measured entities will be able to claim, now this is one of the huge incentives. If you're a YES company, all of the money that you spend in skills development on the people who are your YES candidates, you will be able to claim up to 50% of that expenditure. You will be able to claim up to 50% of that expenditure for what we call internal non-accredited training. In the YES regulations, it lists A to G as the different A, B, C, D, E, F, G, A, B, C, D, E, F, G, 7 categories, of which the last 2 categories are what 50% of your skills expenditure on the YES candidates. You can use up to 50% of what you have to spend on skills on those YES candidates without that training and that development work having to be accredited by SAQA. That's essentially what this means. So it's product training, it's induction training, it's on-the-job coaching and mentoring and even monitoring and performance appraising for purposes of skilling. All of that kind of stuff that you might have defined and designed in your company, which doesn't go through an ETQA or a SAQA NQF-based process, you can spend up to 50% of your skills development spend as informal training on those individuals. Any questions about that? Because that is a major, major advantage. All right, moving on. Placement of black youth can be for exempted micro-enterprises and qualifying small enterprises, including EME and QSE non-profit organizations. Entities may place eligible employees in entities irrespective of size to ensure a quality work experience. Now, this is critically important. If you can't absorb these YES candidates in your company, you can outsource the responsibility for housing them, for training them, for developing them on the job, for coaching and mentoring them. You can outsource that to one of your suppliers. And there's no definition of your suppliers outside of the fact that they have to be small and QSE companies, and more importantly, that they have to take on the responsibility. You provide the funding, they take on the responsibility, and they, the company, gets the advantage of being able to count that as a successful YES contract. But here's the kicker. You that receive those individuals also have to then be registered with the Yes non-profit organization. So in that instance, both entities have to be registered with the Yes non-profit organization. I'm going to again ask, are there any questions? Because these are all quite intricate issues, which surely there are questions about. But if there are not, I will carry on until someone unmutes their microphone. Okay. As far as exempt and EMEs and at least 51% black-owned or more QSEs that participate with the Yes initiative will be verified against the QSE scorecard. So an EME that wants to be a Yes company because it wants to jump levels essentially, or it wants to create an incubator for its clients, a Yes incubator for its clients, will have to comply with the QSE scorecard, which is either generic or a charter scorecard for particular industries, such as, for example, construction or the MAC charter, okay, and will not be entitled to simply submit an affidavit to say it does less than 10 million rand a year turnover and automatically be regarded as a level 4 company or a level 2 company if it's 51% black owned. So it will have to be verified against all 5 elements of the generic scorecard, or in some instances, if it's covered by a charter council, such as the MAC Charter Council, it will need to be verified against all 6 elements of the MAC Charter Council. Any questions about that?
Good morning, Ivor.
Hi, Zach.
Just William Joshua. Just a quick question. Good yourself.
Fine, thanks. What can I do for you, sir?
In terms of the incubator, if let's call it the incubation is outsourced to a third party, does that third party have to register in the same sector with the same sector requirements as the original, let's call it the top company or the non-complying entity?
William, that's a beautiful question, because just to explain its implication, what you're saying is this. Let's say you've got a client in the construction sector, but let's say you're a media advertising communications kind of company. And you're saying to, it's a large client in the construction sector, so you're saying to that large client, what we can do is we can create a marketing team or a social networking team for you by running an incubator specifically around that example of your employee workforce. And if your target is 8, and if we can absorb those 8 people into our incubator, you will register as a Yes company covered by the construction sector charter codes, and we will register as a Yes company covered by the media advertising communication or the MAC charter code. That's how it will work. There's no problem with that, because in fact both companies are then monitored by the Yes non-profit company. The only question, William, is this, and it's the first time I'm thinking about this question based on your question to me, and so only Yes will be able to answer this, but the question is, will the construction company need to pay the 1,700 Rand, or in fact it will be 5,000 Rand because it will be a large company, per candidate? And then will the incubator company have to double up on that payment? Because remember, the Yes non-profit company is going to have to monitor both of those companies for different reasons and for different purposes. That's an unanswered question. It's well worth asking, Charles, and maybe it should be the employer association that addresses that question to the Yes non-profit company.
Okay, thank you.
William, that was a fantastic question. Thank you so much, sir.
Thank you.
Right, guys, any other questions before I carry on? Okay, moving on. Triple BE recognition will only be applicable for the creation of Yes jobs under the Yes initiative for eligible employees who are unemployed at the time of registering. So it is not the equivalent in the learnership of an 18.1 and an 18.2 opportunity. This is only an 18.2 opportunity. It is only an opportunity to take previously unemployed individuals, and if you want, and it's your election, unskilled individuals, and I'll talk about that now, into the Yes program. It is not to take an existing employee and put them onto a Yes 1-year fixed-term contract of employee. The Labour Court, the CCMA, and the Labour Court will have a field time with you if you try something like that. because it's a labor relations no-go area. And in fact, the original regulations say the YES program is not about labor replacement. It's not about how you get rid of people and replace them with new, younger candidates on the YES incubator. It has to be in addition to your existing headcount, and you cannot convert some of your existing headcount into YES candidates. So it's absolutely critical, guys, that you do understand that. I just want to deal with this unemployed issue for a moment. So originally, the YES program was linked to fees must fall. In other words, it was designed initially to say, take those kids who've graduated from university with a degree and put them into a one-year work experience called the Youth Employment Service, and you can be a YES company. After May of this year, there was significant amount of kickback on that proposal from business, particularly small businesses, that said, we can create these jobs, but we don't want them to be linked to university education because, number one, we know how pathetic university education is and how unrelated to the workplace it is. Number two, we know the cost of bringing someone in with a university degree in terms of having to retrain them in the workplace. And number three, the vast majority of our YES opportunities are opportunities which are created at entry level in our companies and not at graduate level in our companies. So because of that significant kickback to the regulations that DTI put out, DTI de-linked. They took out the linking to the university qualifications or higher education qualifications. So as a result now, what unemployed means, the criteria that these individuals are unemployed, unemployed means this, that you're able to advertise for a YES candidate who already has a qualification that you're seeking. In other words, you don't want to do the training and the internship and even the learnership of the individual. They should already have been through that process so that they can hit the ground running in your business. Or you create a YES opportunity at the entry level of where you would employ from unskilled and unemployed people into your business. Either is fine. Now, how do we know that either is fine? We know that either is fine because one of the remaining gray areas of the regulation is how much you would need to pay a YES candidate. There is an elusive, very gray reference to a minimum of 55,000 Rand for the year to the individual. And it's very gray because it's not clarified or clear yet. Then we know that the ETI, which has now also been linked to YES, the ETI level has been raised from 3,600 to 8,000 as the ceiling you can be paying those ETI candidates if you're linking ETI to YES. So we know that at the very least you've got between that 55,000 Rand a year and the 8,000 Rand a month is the indicator. But quite frankly, whatever your entry-level position is in your company or that entry-level band, and whatever you're paying in that band will in fact be more than those amounts or at least those amounts. And therefore, you know, you can link your YES incubator to those levels. Now, what's interesting is this. One of the big gaps that companies have in the workplace is in terms of the whole issue of management control when it comes to triple BE. Companies are losing a lot of points because they don't have black managers and particularly black female managers in the critical positions within their companies. And so their verification agents are just not able to give them points despite who they've actually got on their organogram. Now, what you're able to do if you're clever is create a YES incubator specifically for the managers in your business, and in the process, define those as entry-level acting manager positions, where as long as those people have staff reporting to them and a job description that they're aspiring to over that 12-month period, they will be entitled to count those as YES candidates. What you pay them will be significantly lower than what you would be paying managers, etc., because it's an acting manager position, a trainee manager position, but on the job and in the workplace. So it's not an internship or a registered apprenticeship or a registered learnership. It is as clear as mud, I know, but it's only because these are new concepts and we're having to work through how they will work in practice and reality. But because it is as clear as mud, It is an art at this stage and not a science. It is a process to be defined. It is a dispute of right rather than a dispute of interest, if a dispute ever arises. Any questions about that? Because I know that was a very complex issue I've just addressed.
William, again, just another question.
Right, okay.
When you talk about the unemployment or the definition of unemployment, is there a specific period coupled to that unemployment? So, for instance, 6 months or 12 months or something like that.
No, if the person is unemployed, they're unemployed. At this stage, there are no criteria conditions except to say they're not employed by your company. So it's very interesting what you're saying, because we've seen this with some of the ETI programs, that a candidate will join an ETI program saying that they're unskilled and unemployed, and then either they've hidden it, or after they've joined the program, they then take a job somewhere. And where it crops up is they're then involved in the ETI program, and they're working somewhere else in the process. And it crops up when SARS then do their EMP returns. So SARS actually then says to the person, you're registered with 2 different tax numbers, what's going on here? Or rather with 2 different employer numbers, what's going on here? So in answer to your question, there's no definition of unemployed except to be unemployed with that particular business. The rest will be dealt with, I'd imagine, on a case-by-case basis.
Okay, thank you.
Janelle has said, Ivor, please go over that opportunity, read the manager incubator. Janelle, what I'm saying is this. If a company employs 1,000 people, but the company in its own verification has lost points on triple BE on the management control element, because it doesn't have black managers and black female managers in critical positions within the company. And I'm going to say, just because of my own experiences with my clients, not Indian, not colored. Specifically, the gap is in the black community rather than the Indian, the colored, or the Chinese communities. All right? That it doesn't have specific black people in positions of managerial control in the business at the various levels. What that company can do is say, right, we're gonna implement an incubation process for acting managers, trainee managers, if you want, on the workplace. In the workplace, on the job, coached by supervisors, senior managers, and mentored by those senior managers over a 12-month period at entry level. And then we're going to employ the 2.5% or more that we need to employ at the end of that 12-month period as actual managers. Your verification agents are entitled to accept that as management control, as long as those individuals have people reporting to them and have managerial responsibilities, even if they're only acting or trainee managers in the process. So the only thing I can think of as an example, and please forgive me for using the name of a company or 2 companies, but you'll know that Edgar's used to do it, Woolworths used to do it. They used to have a management development process in place in their company. That is exactly what the Yes Incubator for managers would look like, what those management development programs look like within the old Woolworths or Edgar's environments. And I don't know if they still run them, but that's certainly what a Yes Incubator might be. Remembering that it's not a registered learnership or internship or apprenticeship. I hope I've answered your question as best I can, Janelle. Again, I know it remains clear as mud, only because, guys haven't started to work with the concepts. Okay. So she says, thank you, and they must be unemployed, right? Yes, they must be unemployed. They cannot be existing. Well, it's an interesting question. Ordinarily, you would want to take someone who's in your company, exposed to your company, for those people to be on a management training program. Ordinarily, that's always the first source of where you get your managers from. So I would imagine that on a case-by-case basis, the Yes non-profit company will be asked to make exceptions based specifically on the 18.1 relationship of that Yes candidate that you're trying to get an exemption made. There is certainly nothing in the regulations that prevents them from doing it. So it is making an exception, I'm saying. So it is certainly, I think, worthwhile dealing with the Yes non-profit company and asking the question, can we be exempt for our management development processes, because we want to incubate some trainee or assistant managers, and we'd like to use the YES vehicle. They could say no, and therefore set a blanket standard across the country that you can't do that. In other words, you have to take new graduates, management graduates, into the program. You can't do it for existing employees. I also think it's about and excuse me for using this term, I really apologize, but about the balls of the organized labor movement, the trade unions, to stand up and say, if that's the way the YES non-profit company is going to interpret these regulations, then management should be excluded from the YES process, or a management candidate should be excluded from the YES process, because otherwise existing trade union members would be excluded from the process unless there were exceptions made and companies were allowed to take from within into those YES programs, which were management incubators. So it's really about the gravitas, the insight, the ability of the trade union movement to make that argument. And quite frankly, I don't know if I'd hold my breath in that regard, but maybe I'll be very pleasantly surprised in the future. All right. So there is a slide that gives you all of the links. And I think you need to look at that slide, and you need to try and exhaust those links. If you're a YES measured, or you want to be a YES measured entity, there's a information slide. If you want to be a host entity, there's a slide on how you register as a host. But there I'd ask the question, does that registration fee per candidate get paid twice, by the host and by the lead? If you're a skilled service provider, there's a slide there, because you can still provide services, but they have to be demarcated and ring-fenced. If you're an implementation partner and service provider, such as a business association, trade association, I suppose a bargaining council might try and do these things. There are 2 pages there that you could be, they're the same page. Then if just for general information and queries, there's also a link there. So those are the links you'd want to be using. I don't know if you want me to tell you how the sub-minimums are calculated. It's safe to say that unless an exemption is made by YES, the YES non-profit company, you have to meet your sub-minimums. And in meeting your sub-minimums, as a practical example, if you're a large company doing more than 50 million rand turnover, you have to get a minimum of 3.2 points on ownership. You have to get a minimum of 8 points out of 20 points on skills development expenditure. You have to get at least 10 points out of 25 points on preferential procurement. You shouldn't be in business if you're dealing with preferential procurement and you're not getting those minimums. Supplier development, 4 out of 10 points. And enterprise development, 2 out of 5 points. Those are not difficult points to get. If you're not getting those points, you're not going to be anywhere close to being able to be a YES company. I'm going to tell that to you now. There is also, if you're skipping some of those points, there has to be a 50% average of those sub-minimums within a large company. All right. Then, there are sub-minimums for the QSEs, which are basically the same kind of, exactly the same points. Those sub-minimums. All right. Now, it's important that you understand YES targets. How the company's YES target is, in fact, calculated. So if it's a large company doing more than 50 million rand a year turnover, there are 3 mechanisms to determine the YES target. There's a headcount mechanism, there is a net profit after tax mechanism, and then in fact there is a table. It's called Table 1 of Annexure A of the regulations. And in fact the reason there are 3 mechanisms is because YES, the YES company, the YES non-profit company, will accept your target at the highest level, not at the lowest level. So the highest of those 3 mechanisms of determining your target is the one that will apply. Once you meet those targets and you meet the absorption 2.5% requirement of that target, you will automatically be able to skip 1 triple BE level, irrespective of what you've been verified at. And if you double that target and 5% of that doubled target is then absorbed, you will be able to skip 2 levels. There is an intermediate level, by the way, and that is where you would achieve 1.5% of your target, where in fact you would skip one level, but you would also get an additional 3 points towards your triple BE verification, which in many instances might very well mean that you skip 2 triple BE levels anyway. Any questions about that for large generic entities? Okay, I'm not going to go into the other specifics. So for QSEs, in other words, companies doing less than 50 million rand a year, but more than 10 million rand, or for exempt companies, emerging exempt companies doing less than 10 million rand turnover a year, there are 2 mechanisms. There's a headcount mechanism, or there's a table that would be applied. But it's the table that would be applied rather than the headcount mechanism. So the table would determine what increase in your headcount you have to be achieving. Sorry, I just had something else in my mind, so I misspoke there for a moment. Okay. So your triple BE verification agent is ultimately the go-to organization for you to get authorization to skip a triple BE level or to skip 2 triple BE levels. And the South African National Accreditation Agency, or SANAS, accredits those verification agents. SANAS as yet haven't come out with practice guidelines for verification agents based on the DTI practice guideline. It is very possible that the SANAS instructions to verification agents will be more detailed and more specific than the practice note that DTI has now published, but we await to see that. So at the very least, these verification agents will want to see that you've registered with a Yes non-profit company. It will want to see that you were previously verified and that you've been consistent with your verification. That it will want to see that you've not used Yes to displace your current employees within your company. And in fact, you've not used Yes to disrupt your skills development, your management control, but it's being used to supplement those elements. In other words, practically what that means is, if you know that you're going to fall away with your skills expenditure, and therefore you implement a Yes project, to compensate for the fall away and the drop off, instead of to evidence an increase in skills expenditure, or at least an increase in headcount, then your verification agent won't accept that for triple BE purposes. You will have to have supplied your audited financial statements for the last 3 years to calculate your net profit after tax targets. Remember, for large companies, that's one of the 3 mechanisms. And for the verification requirement linked to employment, it will be linked to your EEA2 report, and it will also be linked to your EEA. Apologies, I was dropped off, but I've just rejoined. I hope you can hear me. Charles, can you just indicate if you can hear me?
Yes, we lost you there.
Okay.
So also you're loading, just okay, so that you know. Maybe just wait.
So
there we go.
All right. So okay. So also your EEA4 report, proof of submission of those 2 reports to the Department of Labor, if it's applicable. Employee list is a measurement date to calculate your headcount target. So remember, they want to see that you've grown in headcount because of Yes for a 12-month period. And then at the end of it, for absorption, they want to see that you've grown in headcount at least by your 2.5% absorption target. And your payroll report closest to your measurement date, obviously, to verify those activities. Samples of your certified copies of the IDs of the black youth, black people who've been included as candidates, because there is a lot of obfuscation, hiding, and quite frankly, fraud going on in that arena. I can't tell you the number of companies where I've come across white employees who for whatever reason were registered by Home Affairs as black individuals who have been included in a whole series of black triple BE target measurements where their IDs clearly show that they're white people and not black people despite their name in the Department of Home Affairs registration. There's a whole lot of nonsense going out there, but I must say it's mostly if there's disability involved, then obviously you need your doctor's reports for disabilities, and then signed employee workplace contracts, critically important. And then there will be interviews as well, which are conducted by your verification agents, who then sample your candidates as they would for your normal verification visits. So when the verification agent talks about skills development, these are the things I want to see. Again, your EMP 201s for the measurement period, your workplace skill plan and your annual training reports have to have been submitted. Your skills development expenditure list for the measurement period needs to have been submitted. Now, the first time you're doing this and you're not yet a YES company, you cannot in that skills development expenditure list include the 50% of F and G, or the last two categories of those 7 categories of training. You can only do that the year after. So then you can only include up to 15% of skills expenditure on those categories of expenditure for internal training. Your skills development matrix, which would come out of your workplace skills plan, samples of proof of attendance, samples of certified copies, and the various documents, including invoices and receipts, and for disabled people, doctors' declarations, etc., etc. All right, so I have come to the end of my discussion. I'd like to know from you if there are any questions you would like me to be dealing with. No questions. Sorry, Natasha asks us, how will industry prevent companies from ending current contracts of flexible workforce, giving the current legislation on deeming, and then creating YES opportunities elsewhere in their business, which is not in alignment with the LRA? Well, no, not necessarily. So, Natasha, let's take this thing to its ultimate conclusion. So here we've got, let's say, 10 people who I use in my business via a contract from a temporary employment company, comes to an end, and because of the Constitutional Court ruling, I am now deemed the employer, so we end that relationship. Those people are outside of my workplace. The temporary employment company says to my company then, we're a qualifying, if you want, a lead employer, as long as you want to remain a host employer of these individuals. These people who were previously temps in your business have had great exposure to your business, and therefore they're an asset if they're included in a 1-year fixed-term contract for 12 months as a YES program. We will register this program with the YES non-profit company. You will register as a host employer and a funding employer with the YES non-profit company. There's nothing illegal about doing that, as long as there's no continued deployment into the workplace. Your explanation for why these people are no longer working in the company is because of the Constitutional Court ruling and the fact that the company has moved away from temporary employment service agreements because of that Constitutional Court ruling. And they've instead moved towards a YES fixed-term contract. And the Constitutional Court said any fixed-term contract, which is a reasonable fixed-term contract for a ring-fenced period of time for a specific reason, is not an illegal contract. That was part of the Constitutional Court ruling. So, Natasha, in response to your question, there's absolutely nothing illegal about that. Megan says, thanks for the great presentation. Nothing from our side. All right. So if there are not further questions, and I'll just ask again, if there are any questions, please ask your questions. Otherwise, Charles, thank you for organizing this. It's been a pleasure running it, and I hope it's been of use to you and your members.
Yeah, it was great. Thank you so much, Ivan. Can I just ask you to just send me the presentation and I'll forward it to everyone?
I will do that. Thank you so much.
Thank you.
Thanks, guys.